One wrong word during a police stop, and your legal gun ownership could turn into a felony charge. I'm talking about specific phrases that cops are trained to use against you in court, even when you think you're being cooperative and honest. Today, I'm breaking down the 5 most dangerous words gun owners say to police that destroy their legal defense. By the end of this video, you'll know exactly what to say and what to never say when cops ask about your firearm. This isn't theoretical. Last month in Texas, a concealed carry holder said just 3 words during a traffic stop. Those 3 words cost him his carry permit, $15,000 in legal fees, and 2 years of court battles. He thought he was doing the right thing. He was dead wrong. Number 1, I didn't know. When a police officer discovers you're carrying in a prohibited zone, maybe a post office, a school parking lot, or a government building, your first instinct is to explain yourself. And the most common response? I didn't know that was illegal. Here's the problem. Under the legal doctrine of ignorance of the law, saying, I didn't know, is not a defense. In fact, it's an admission of guilt. You've just confirmed to the officer that you committed the act. You're carrying in a prohibited area. The only question was intent, and you just eliminated any possible defense your attorney could build around that. In 2023, a Louisiana gun owner said exactly this when caught carrying in a courthouse parking area. The prosecutor used his own words against him. Result: Class B misdemeanor, $2,000 fine, mandatory surrender of his concealed carry permit for 3 years. His lawyer later said the case might have been dismissed if he'd simply remained silent. Here's what you do instead. If an officer tells you you're in violation, say nothing about what you knew or didn't know. Your only response, I'd like to speak with an attorney before answering questions. That's it. Your lawyer can address knowledge and intent later when they have time to research the actual statute and build a proper defense. But here's the critical part most gun owners miss. And this next phrase is even more dangerous because it sounds helpful. Number 2, it's just in my truck. You're pulled over for a broken taillight. The officer asks if there are any weapons in the vehicle. You want to be cooperative, so you say, yeah, it's just in my truck, or it's just in the glove box. That word just legally translates to admission of possession and control. In court, prosecutors will argue you knowingly had the firearm exactly where you placed it. If that location happens to violate any local ordinance, maybe you're parked near a school, maybe you cross state lines with different storage laws, maybe your permit doesn't cover vehicle carry, you've just given them everything they need. Florida, 2022. A gun owner told an officer his pistol was just under the seat. The officer discovered it was loaded and not in a secured container. Under Florida Statute 790.25, that's illegal without a carry permit in certain circumstances. The gun owner had a permit, but it had expired 2 weeks prior. His own statement about location and accessibility was used to prove he had immediate access to the weapon, escalating the charge to carrying a concealed weapon without a license. That's a third-degree felony. 5 years possible prison time. Your correct response: if you're legally required to notify an officer in your state, you say, I'm notifying you I'm a legal permit holder. Period. No location, no description, no explanations. They'll ask where it is. You respond, I'd prefer to discuss that with my attorney present. This sounds uncooperative. I understand that. But cooperation during a stop doesn't mean volunteering information that can be weaponized against you later. Which brings us to the third phrase, and this one gets gun owners arrested more than any other. Number 3, I have a permit. Wait, isn't that exactly what you're supposed to say? Not quite. The problem isn't telling the officer you're permitted. The problem is what usually comes after. Here's how it plays out. You say, I have a permit, and the officer asks to see it. You reach for your wallet, but your permit expired last month and you forgot to renew. Or you moved states and didn't realize your old permit isn't recognized here, or you're in a jurisdiction that doesn't honor your specific permit type. Now you've made a false statement to a police officer. That's a separate crime in 43 states. In Virginia, it's a Class 1 misdemeanor, up to 12 months in jail, and a $2,500 fine just for the false statement, completely separate from any gun charges. Tennessee, 2024. A concealed carry holder told an officer, I have a permit. During a traffic stop, the officer ran his information and discovered his permit was suspended due to an unpaid traffic ticket from 6 months earlier. The gun owner had no idea about the suspension. The prosecutor charged him with carrying without a permit and making a false statement to law enforcement. Total cost $8,000 in legal fees, 40 hours community service, and a permanent mark on his record that shows up on every background check. The safer phrasing, I'm a permit holder and I'd like to verify my current status with my attorney before proceeding. If your permit is valid, your attorney confirms that immediately and you're clear. If there's an issue, an administrative problem, a lapsed renewal, a reciprocity question, your attorney handles it before you've made any statements that can be used against you. Now, the fourth phrase is one that feels protective, like you're establishing your rights, but it's actually giving prosecutors ammunition they'll use to argue intent. Number 4, it's for protection. An officer asks why you're carrying. You want to sound reasonable, responsible, law-abiding. So you explain it's for protection, or I carry for self-defense, or you never know what could happen. You've just established motive and intent. If your carry situation is later determined to be illegal, wrong location, wrong permit, wrong state, prosecutors now have your own words proving you intended to have that weapon available for use. That elevates the charge in many jurisdictions. California has some of the strictest gun laws in the country. In 2023, a CCW holder was caught carrying in a posted no-gun zone. When asked why he was carrying, he said, "For protection, there's been crime in this area." The prosecutor used that statement to argue he made a conscious decision to violate the posting because he valued his safety over the law that turned a potential misdemeanor into a charge of willfully violating firearms restrictions. He spent $12,000 fighting it over 18 months. Here's what the law sees. If you say you're carrying for protection and you're later found to be in violation, you've admitted you knew you had the gun and you intended to use it if necessary. Both of those elements, knowledge and intent, are exactly what prosecutors need to pursue higher charges. Your response when asked why you're carrying: "I'd like to speak with an attorney." That's the only answer that protects you. Don't justify, don't explain, don't give them anything to work with. But the fifth phrase, this is the one that destroys more legal defenses than anything else. And I guarantee you thought about saying it. Number 5, I wasn't going to use it. This is panic mode. The officer finds your gun and you immediately want to de-escalate the situation. So you say something like, "I wasn't going to use it," or "I forgot it was even there," or "I never touched it. Congratulations." You just confessed to illegal possession while simultaneously destroying your Fourth Amendment defense. When you say, "I wasn't going to use it," you're confirming you knew the gun was there. That eliminates any argument that the gun was planted, that you didn't know it was in your vehicle, or that someone else put it there. You've locked yourself into possession. When you say, "I forgot it was there," you're admitting negligence. In states with safe storage laws or in cases involving prohibited persons, negligence can be a separate criminal charge. You've just handed prosecutors a second violation. When you say, "I never touched it," you're opening yourself up to forensic examination. If your fingerprints are on that gun, and they will be if you own it, you've now made a false statement. That's another charge. Georgia 2023. A gun owner was pulled over with a firearm visible in the back seat. When the officer approached, the owner immediately said, "I'm not going to use it. I forgot it was back there after the range." The officer cited him for improper storage and transport. The prosecutor used his own statement to prove he knew the gun was in the vehicle, but failed to secure it properly under Georgia law. That should have been a $100 fine. His statement turned it into a misdemeanor with a $1,000 fine and mandatory firearm safety course. The correct response: if an officer discovers your firearm, silence. Literally say nothing. If the officer asks you about it, your answer is, "I'm invoking my right to remain silent and would like to speak with an attorney." That sounds harsh, I know, but here's what you need to understand. Anything you say in that moment is about protecting the officer's safety and building the state's case. Nothing you say will make the situation better. It can only make it worse. Let's recap the 5 phrases that could destroy your legal defense when police ask about your gun. "I didn't know." This admits guilt and eliminates your ignorance defense. "It's just in my truck." This proves possession and control in a specific location. "I have a permit." This opens you up to false statement charges if anything is wrong. "It's for protection." This establishes intent that prosecutors will use against you. "I wasn't going to use it." This confirms knowledge and destroys your Fourth Amendment defense. Any one of these statements could cost you thousands in legal fees, your carry permit, or your freedom entirely. When police ask about your gun, your only safe response is, "I'm invoking my right to remain silent and would like to speak with an attorney." I know that feels extreme, but your words during a police stop are permanent. They're recorded. They're used in court and they cannot be taken back. Silence protects you. Cooperation through your attorney protects you. Volunteering information destroys you. Don't let one wrong sentence turn a legal gun ownership situation into a criminal case. Subscribe to Guns Law Guide so you never miss an update that could keep you out of court. I break down the laws gun owners actually need to know every single week. Next video, I'm covering the 7 places your concealed carry permit doesn't protect you, and one of them is probably in your daily routine. You're going to want to see this before you carry another.